There is a movement across our nation to rein in the power and jurisdiction of an overreaching federal government through use of the tool the framers of our Constitution gave us exactly for this purpose when they wrote Article 5 of our Constitution. Article 5 not only gives Congress the power to amend the Constitution, but also gives the people, through their state legislatures, the same ability if 2/3 of the states submit the same application. The Convention of States project has designed the application that is currently working its way through 35 state legislatures and has already been passed in 4. While most conservative Americans wholly support this movement, 2 established groups, the John Birch Society and the Eagle Forum, are adamantly opposed and are attempting to scare the public and state legislators through a series of untrue allegations about the Article 5 Convention of States process. One such allegation is that such a convention would be a runaway convention, whereby the delegates would not follow any rules and completely rewrite our Constitution. They point to the Philadelphia Convention that produced our Constitution, claiming that it was a runaway convention because the founders' mandate was only to revise the Articles of the Confederation, but instead they created a whole new political system. They also point out that because the Constitution was ratified by only 9 states instead of all the states under the Articles, the rules were broken again, and the Constitution was ratified illegally. Here are the facts concerning these allegations, starting with that convention. On September 14, 1786, the Annapolis Convention recommended to the states, not to Congress, a new gathering, quote, to take into consideration the situation of the United States, to devise such further provisions as shall appear to them necessary to render the Constitution of the federal government adequate to the exigencies of the Union, unquote. As you can see, that proposal was not limited to merely changing or amending the Articles. The Confederation Congress appointed a committee, but it took no other action. Over the next few months, 7 of the 13 states authorized appointment of delegates. None of these states limited their delegates to proposing amendments to the Articles. On the contrary, the authorization was very broad. Typical was Georgia, which empowered its delegates to discuss, quote, all such alterations and farther provisions as may be necessary to render the federal Constitution adequate to the exigencies of the Union, unquote. All 18th century dictionaries make it clear that in the discourse of the time, the term Constitution usually meant the entire political system, not merely the Articles or any particular document. In other words, the delegates were given full power to suggest changes in the entire political system. In February 1787, a congressional committee report suggested that Congress lend moral support to the convention idea, also urging that the delegates receive very broad authority. However, the congressmen from New York, which was then a notoriously anti-federalist state, objected. So Congress toned down the recommendation to suggest the convention be limited only to amending the Articles. But Congress's resolution was a legal irrelevancy. The resolution itself said that it was merely a statement of opinion. Under the Articles, Congress had no power to call a convention, and certainly no power to limit it. Under law of the time, only the states empowered their delegates and set the limits. The states did so in formal documents called credentials or commissions. Those who charge a runaway assumed that Congress's resolution was legally binding. But everyone at that time realized it was a suggestion only. In the ensuing weeks, the 6 remaining states made their decisions. South Carolina, Maryland, and Connecticut disregarded Congress's suggested limits and gave their delegates enough power to consider the entire political system. Rhode Island elected not to participate, and 2 states, Massachusetts and New York, sent delegates but accepted the restriction in Congress's resolution. So 12 states attended the convention, and all but 2 had given their delegates authority to recommend scrapping the articles. Delaware had insisted that its delegates not vote for any measure that abandoned the one state, one vote rule in the unicameral Confederation Congress. But you can make a good argument that this didn't apply to an entirely new Congress with a bicameral legislature in which the Senate represented all states equally. At the convention, it soon became clear that the overwhelming majority of delegates and delegations wanted to scrap the articles and had authority to do so. This put the 3 New York representatives and the 4 Massachusetts representatives in a quandary. What should they do? One Massachusetts delegate, Caleb Strong, had to return home to a sick wife, so he was spared a decision. Another Massachusetts delegate, Elbridge Gerry, refused to sign. The other 2 did sign. Of the 3 New Yorkers, 2 concluded the convention had gone beyond the scope of their personal authority, so they properly returned home. The other New York delegate was Alexander Hamilton, who did participate and sign. However, he did so only as an individual, not as a representative of his state. Since the majority of the New York delegates left, his authority vanished. The bottom line is this. Of the 55 delegates, 48 had authority to go beyond amending the articles. Of the 7 who didn't, only 3 opted to sign the Constitution, and only 2 did so in an official capacity. This convention could hardly be termed a runaway. This brings us to the second charge, the fact that the Constitution was to be ratified by just 9 states instead of the unanimous vote of 13 states required by the Articles of Confederation. Rather than focusing on the number of states required for ratification, there was actually a more important change in the process. Under the Articles, proposed amendments were to be sent to the state legislatures. Under the Constitution, they were to be ratified by state conventions. Before we can even consider the switch from 13 states to 9, we have to ask, how would the switch made from ratification by legislatures to ratification by conventions? If things were going to be done properly under the Articles of Confederation, then all 13 states would have to approve of this change in process before the Constitution could be legally adopted by this new method. Remember, the new method had 2 components. Look again at the language from Congress that approved the work of the Constitutional Convention. Congress did not send the Constitution to the state conventions. The report was transmitted to the several state legislatures. The legislatures had to act if they agreed to authorize the election of delegates in conformity to the resolves of the convention. This last clause meant that the states were being asked to approve this new procedure that authorized the election of delegates to a ratification convention, and 9 ratifications would be sufficient. Both matters were clearly specified in the resolves of the convention. So before any state could submit the proposed Constitution to a ratification convention, its state legislature had to approve this new process. As long as all 13 state legislatures approved the change in process, then it would be perfectly legal under the Articles for 9 state conventions to ratify the Constitution. Without the approval for the change in process by the legislatures, it would not be legal to submit the Constitution to state conventions, no matter how many ratifications were required for approval. 11 states held ratification conventions and approved the Constitution between December 17, 1787, and July 26, 1788. The government under the Constitution went into effect on March 4, 1789. Each of these states voted to approve the new process, since these conventions required prior legislative approval. North Carolina and Rhode Island did not ratify the Constitution before it was put in operation. If North Carolina and Rhode Island had failed to approve or had rejected this change in process, then the critics would be right. The Constitution would have been adopted contrary to the rules of the Articles of Confederation, requiring unanimity among the states. The North Carolina legislature approved this change in process as the legislature authorized the election of delegates for this purpose. On August 2, 1788, the North Carolina Convention tabled any further consideration of the Constitution by a vote of 183 to 83. It is generally thought that Rhode Island ignored the entire process until after the new government under the Constitution had already begun operation. However, in February 1788, the legislature of Rhode Island adopted a resolution submitting the Constitution of the United States to a vote of all the people of the state. In effect, this act appointed all the people of the entire state as delegates to the ratification convention. The people were to assemble on the 4th Monday of March in, quote, conventions, unquote, in each town. These Rhode Island ratification conventions were different from those in any other state, but nothing in the text of the transmittal from Congress prohibited Rhode Island from adopting this format for a ratification convention. The Rhode Island legislature approved the process that had been suggested by the Philadelphia Convention and had been officially approved by Congress. Without this approval by the legislature, the town conventions could never have been held. Therefore, the Articles of Confederation were fully satisfied. Before the Constitution was agreed to, Congress and all 13 state legislatures approved a new process for changing the Articles of Confederation. By the unanimous action of 13 state legislatures, ratification conventions were convened, and explicit approval of a new process that included the transfer of decision-making from legislatures to conventions and changed the required number of approvals from 13 to 9. Both of these accusations against the Constitution are disproved by careful examination of the multiple steps in the process. The Constitutional Convention did not exceed its authority, and moreover, Congress and all 13 state legislatures approved the new ratification process as required by the Articles. The Constitution of the United States was legally adopted.